I'm going through a lot right now.
I read the report. I'm not concerned.
Oh, okay. I just wanted to make sure because I just went back to work and I work in the doctor's office. It's kind of hard to be going back. I can be I'm a surgical assistant. So if I'm in surgery and my alarm go off that I got to blow, once I get out of surgery, I might forget. It's just too much. If it was something different, I do, but I can't, that blow thing is, I got a lot going on with working in a doctor's office. And that was it. I just wanted to let you know that is, I'm going through a lot right now. I'm going to grieving too about my mom with my insurance company, my medical insurance and everything. So there's a lot going on in my life right now. Besides all of this, there's a lot going on.
And how's your daughter doing in college?
She's doing
Who stands to my right.
Name again?
Miles Roberts.
Thank you. All right. Good. You had read the pre-sentence report, no material deletions, corrections, or additions. Anything two of you'd like to say before I propose sentence?
Yes, Your Honor, just by way of explanation. So my client is gainfully employed. She also has her own separate home care business. This is her first time ever having a drunk driving situation. So she's very remorseful about it. Her mother passed away on June 30th. So that she had been grieving and had time off of work. I did notice the violations, and she had explained that for the July 30th violation, her daughter was going for her first college to go to Wilberforce. So that she said August 4th was her first day back to work. I would note that all the testing that she did was resulting in negative testing results. As far as the payment, she said she'll need till Friday to make that payment of the $264 because that's when she gets paid. Okay. Oh, she's saying she can pay $120 today. I did notice that the order recommending. Let's see, it's the violation order. Looking at it, it said that there would comply with the order 3 times a day. I would just note for the court that this is her first time having this offense, doesn't have a history. She was out with a friend and she said she was at the light and the person came out of nowhere. And so we're requesting that we abide by the report, but we are requesting that she be given the opportunity to, if not, or just discontinue with the sober link, or at least have a reduced time, come back after she's had a period of compliance and come off the sober link. We also provided the verification that she did comply with that was for the MAD, the Mothers Against Drunk Driving class, and the sober link listing, which we emailed to the court in this Pilar. So, and did you want to say something to the court? She does want to say something to the court.
Yeah, the time I was wondering for the times that they were saying that I missed. I'm going through a lot right now.
I read the report. I'm not concerned.
Oh, okay. I just wanted to make sure because I just went back to work and I work in the doctor's office. It's kind of hard to be going back. I can be I'm a surgical assistant. So if I'm in surgery and my alarm go off that I got to blow, once I get out of surgery, I might forget. It's just too much. If it was something different, I do, but I can't, that blow thing is, I got a lot going on with working in a doctor's office. And that was it. I just wanted to let you know that is, I'm going through a lot right now. I'm going to grieving too about my mom with my insurance company, my medical insurance and everything. So there's a lot going on in my life right now. Besides all of this, there's a lot going on.
And how's your daughter doing in college?
She's doing great and she's loving it. And I'm really alone now because it was just me and my mom. So my mom gone, it's just my daughter gone. So it's just me.
Yes, Teresa Claire on behalf of probation. Your Honor, I just wanted to let the court know that Ms. Miles Roberts was scheduled for sentencing earlier. My office had to bump that out because there was a possible restitution claim. So she kind of already has gone on the sober link for an extended period of time. because I did have to adjourn that for a possible restitution issue. I never received any follow-up from what was initially sent, so therefore there's no restitution recommended.
Got it.
Okay, but I just wanted the court to be aware that
That she was on it.
an extension of time because it had to be adjourned to hash out and see what was going on with restitution.
Got it. Court does acknowledge this is not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of early intervention in educational programming, attendance at AA meetings, and abstinence from all intoxicants. The court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. So therefore, the sentence of the court, you are placed on probation for a period of 12 months. You are to pay $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $360 probation oversight fees. You're to pay $120 today, and then a payment plan as arranged by probation. You understand that, ma'am?
Yes, I do.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the alcohol highway safety education program. You are to attend one AA meeting per week for a period of 6 weeks with verification to probation. You are to provide proof, and I think you have, of the victims impact panel attendance to probation. How much longer was she on that sober link, Ms. Clara? Do you have a calculation of days?
Let me see.
A month.
So her original sentencing was,
July 8th
yes, July 8th. And it was set for,
today. So it's been longer than the 30 days. All right. I will indicate that she moved from the sober link, so the sober link will be discontinued. She's already done what I would ask be done.
Thank you, Your Honor.
All order 93 days in jail. Credit 1, the balance is sustained. Thanks.
Thank you. Thank you, Your Honor. I hope everybody has a great day.
Hi,
good morning.
perfect timing. We're done with that block.
Oh, great.
Yes. So nice you to stand, but we gotta go. Court stands in recess.
All right.
So this is a show cause for money owed on an old case. Seeing as Mr. Brown is in custody, I'd ask for an adjournment.
You're brilliant. No, come there.
Sorry, I didn't hear you.
I said, when you said he's in custody, I said, oh, you're brilliant. No, I'm coming after the how much is it?
I had 440.
How long have you been in?
About 40 days.
Is there some of it? What do you have?
I'm here. I have a year sentence here. I've told you that. Well, I told my lawyer I had a year sentence here, so I'm gonna be here until April. I didn't procure the money when the last time I came. You told me to come and pay. I think like 100 or something. I didn't procure the funds before I came, so I didn't know I was not going to be able to pay the rest of it.
I'm gonna waive all the fines and costs except the statutory fees. You're all set. Good luck to you and me. Court calls the case, People versus Michael Naparella.
Good morning. This is hearing on behalf of Mr. Navarala, who is in custody in the Ohio Department of Correction.
Your Honor, I can confirm that he is in custody in Ohio. Given that he's not present, I would ask the court to adjourn this out to September 23rd with a writ being done to the Ohio facility.
I'll adjourn this out to, you want the late September date or the October date?
The late September date, I think, would be sufficient.
September 23rd, 2026. Is that at noon or 9 a.m.? There was only one on, correct? Court calls case People versus Jason Haas.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Haas. State your name for the record, please, sir.
Jason Haas.
We did review the sentence recommendation in this case. We ask that you adopt it.
Sir, anything you want to tell the court before I impose sentence?
Just that realize the wrong and working on myself. I'm gonna do better from now on.
Court acknowledges that this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient treatment, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment. Therefore, the sentence of the court, I will place you on probation for a period of 24 months. You are to pay $1,255 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $720 probation oversight fees. When do you think you can get that paid, sir?
Well, after this, I'm gonna go to another county. They want to give me a year.
Pardon?
I'm gonna go to Livingston County after this, and they want to give me a year cap for a UDAA. So I don't know how it's gonna work, sir.
Okay. Here's what I'll do. I'll just indicate that it's to be paid by December 31st, 2026, and then we'll figure out where you are at that point.
Yes, sir.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll report to community corrections within 24 hours to begin weekly random testing. I'll do it this way. If he's going to Livingston, you have to report to community corrections within 24 hours of release.
From Livingston?
Right.
Yes, sir.
You're to complete outpatient substance abuse treatment, including all recommended aftercare with status reports to probation. You're to attend one AA meeting per week with verification to probation. Provide proof of victims impact panel attendance to probation. I'll order 365 days in jail. Credit 27. The balance on this case is suspended.
Thank you, Your Honor.
Thank you.
Oh, man, let's get this.
I'll watch the thing.
Court calls case People versus Kimberly Bronson.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Miss Bronson, who's in custody at the Wayne County Jail.
And Teresa Player on behalf of probation and Your Honor. I did confirm that Miss Bronson, she left our facility and was transferred over to Wayne. So she is there. Probation's asking for an adjournment or writ. In that case, not opposed to September 20th or the 1st October date.
What I'll do is I'll then adjourn this matter to September 23rd, 2026, 9 a.m. What are you doing, Buckovich?
Wait for my case to be called.
No, I was asking, we missed you when we started. And we asked Miss Perrine where you were. And oh my God, her response. I'll let her tell you. She should tell on herself. It was very non-Perrine. Court calls the case People versus Theory Reynolds.
Good. Assistant Public Defender Lauren Perry on behalf of Mr. Reynolds, who is approaching. State your name for the record when you get to the podium, please, sir.
Terry Reynolds, good morning, Your
Good
Honor.
morning, sir.
Your Honor, Mr. Reynolds is also in custody. This is a show cause for money owed. I'd ask for an adjournment of the show cause.
It's the
How long have you been?
110 owed. How long,
Can I-
what are you in for?
Can I say something, Your Honor?
Stop you, I guess. Go ahead.
So I was in here last year from August until November.
You were in custody, you mean?
Yeah, from August to November, I got released, but I had seen you for this apparently. And I was wondering, like, at some point, will I be able to like move for like time served or something? I don't know how much this charge carry or what, but I really don't have no money.
Okay, I know. So how long are you in for right now? What are you in for?
I got a couple charges I'm here for right now. I go to court tomorrow. Actually, I'll see you tomorrow. I'll see you tomorrow.
For me?
Yeah.
What's charged?
Felony.
Well, I know that, but
When did you come to custody?
Uh,
small stuff.
The fifth of
the
this month
fifth.
of August?
Are you under sentence on any case?
No, sir.
So you have that case that's with me tomorrow.
Mm-hmm.
Then that's it? That's all you have right now?
Yes, sir.
You still have it up. What's his bond?
My bond on the case tomorrow, Your Honor. Excuse
Yeah.
me. $1 million.
It's $1 million?
Yes, sir.
In this case is driving while unlicensed, which apparently people do.
Way to be.
So no.
It was I allowed somebody.
No, I don't even want to know. Just here's what I'm going to do. I'm going to waive all the fines and costs except the statutory fees. And that way you're done with this.
Your Honor, excuse me. Thank you first and foremost.
You're
Know
welcome.
what the statutory fee is?
I think it's going to be 125. It's going to be 125, but counsel could explain to you about that.
Okay.
Okay, just
Read back around.
All right. Thank you, Your Honor. I
you're
appreciate.
welcome.
Sorry for speaking too much.
What?
Sorry for speaking too much.
No, you're good. Just don't do that tomorrow.
Oh, man.
All right. Take care. All right. Court calls the case. People versus Devontae Johnson. 2 cases.
Assistant Public Defender Nicholas Breckenridge on behalf of Mr. Johnson.
Welcome back.
Thank you.
All right.
Claire on behalf of probation, Your Honor, Mr. Johnson, I have confirmed is in the Allen County Jail. So therefore I'm asking for an adjournment with a writ to be issued. And September 23rd would be fine with that as well.
I'll adjourn. These are 2 matters, correct?
Yeah.
September 23rd, 2026, 9 a.m. Court calls case. People versus Trayvon G.
Good morning, Assistant Public Defender Lauren Perry on behalf of G.
Sir, state your name.
Trayvon G.
Thank you.
Teresa Claire on behalf of probation, Your Honor, Mr. G is before the court for a review hearing on a prosecutor deferred sentence. Mr. G has completed all terms accepting he has a balance of the $435. Given that he is compliant in all other matters, probation is recommending that the court give an extension of the prosecutor deferred sentence for a period of 3 months, that Mr. G make a payment of $145 beginning on September 1st, 2026, and then $145 per month thereafter. That he continue with all other terms as previously ordered, with the review hearing being set November 16th, 2026 at 9 a.m.
I have no objection. I wasn't able to speak with Mr. G, so I don't know if he has any objection, but I think it's a reasonable recommendation.
Okay. Mr. G, you heard
Yes.
all that?
Yes, I did.
You think you can do that?
Yes, sir.
Okay, so you'll be able to pay 145 each month beginning the 1st of September?
Yes, I will.
Okay. Let's try to get you through this. So I will extend the prosecutor's deferred sentence for a period of 3 months. He's to pay $145 per month beginning September 1st, 2026. Continue all other previous terms as ordered. I'll set a next review hearing for November 16th, 2026, 9 a.m. All right.
Okay.
Thank you, sir.
All right. Thank you. Have a great day.
Court calls case People versus Tyler Meddy.
Good morning, Assistant Public Defender Laura Perry on behalf of Mr. Meddy. Mr. Meddy will not be present. I did speak with him this morning that he was on his way to work and had to be at work at 9:30. While at not be on his phone, so he can't come on. He did want me to request an adjournment. He said he just got this new job. I think it's Lombardi's Food, driving a forklift, so it's a good job. He really shouldn't afford to move at this point, so he was behind on his rent. He did say that he would be able to pay off the rent in about a week or two.
Will that pay everything?
No, there's other client costs. And
Got it.
About $400. He said he could make about a $500 payment in the next couple of weeks.
All right, so here's what I'll do. I'll order that he pay $500 by I'll just make it the end of this month, by October 31st. August 31st, 2026. All right. Then did he indicate to you what he could pay per month or anything like that, or no?
He didn't, Your Honor, but he
Okay.
did say he back to work and it seems to be caught up on his bills.
Right. Okay. So then he's to pay that by that date. I'll adjourn this matter out to October 14th, 2026, 9 a.m. Okay. Court calls case People versus Angela Stoker.
Good morning, Assistant Public Defender Laura Perry on behalf of Ms. Stoker.
Hello.
Hello, Ms. Stoker.
Teresa Claire on behalf of probation. Your Honor, Ms. Stoker is before the court for a review hearing on a prosecuted deferred sentence. Ms. Stoker has completed the programming component. She still has the balance of $390. Was speaking with Ms. Stoker, she had changed jobs. So there was some financial issues. She is working and is steady now. Probation at this point is asking, given that she's compliant with reporting and the programming, that the court extend this prosecutor deferred sentence for 3 months to allow her to complete it successfully. Probation's also asking that she make a $90 payment on or before today. Ms. Stoker, did you make that payment?
I'm gonna do it today.
And then $100 per month thereafter, that all other conditions continue, with the final review hearing being set November 16th, 2026 at 9 a.m.
I have no objections to that, Your Honor. Ms. Stoker indicated she could make the payment. Any objections to any of that, Ms. Stoker?
No.
All right. So you'll be able to make the $90 payment today, right?
Yeah.
Okay. So here's what I'll do. I'll extend your prosecuted deferred sentence for a period of 3 months. Pay the $90 today, and then you're going to pay $100 per month beginning in September. Continue all other terms as previously ordered. I'll set a next review hearing for November 16th, 2026, 9 a.m. All right. Thank you, Ms. Stoker.
Thanks.
Court calls case People versus Brandon. Here yet. Koza? Here you, Koza. Oh boy. Here we go. I'll let everybody stop. All right. She was here. I didn't know she was even going to get to talk today, but now she's going to talk.
Hold on, there's my application. Honor, Mr. Sewell and Mr. Kirkoza is before the court for a review hearing on the prosecutor's jurisdiction. He completed all terms and the issue and provisional events. Probation.
Yeah. Buckervich. Did you know she's a USC Trojan?
No, I didn't know that.
Didn't know that? We don't like them, do we?
I'm neutral.
So ordered, Judge. Thank you. Wow. I'm getting no help over it. Court calls the case People versus Nicholas Stemmel. Oh, she's up again.
Honor, Mr. Sewell is before for a review hearing on the prosecutor's jurisdiction. He's completed all terms and conditions.
All right. The 14A District Court, County of Washington, State of Michigan, Thomas Benson, all the ones that are just public courts on there. Jason.
You may be seated. Court does call the case People versus Desmond Campbell. Sir? Oh, got it. Go ahead, counsel.
Morning, Jeff Perlman on behalf of Desmond Campbell.
All right. Your name, sir?
Yes, Campbell.
All right. Okay. This is date and time set for sentencing. Have you reviewed the pre-sentence report?
Yes.
Yes, Judge, I have, and I have with my client.
All right. Are there any material deletions, corrections, or additions to the report?
There is, in the last indication on his previous record, that's not him. It must be somebody else with a similar name, but there's an indication of a felonious assault. That is not him. Otherwise, everything else is accurate.
You're talking number 7.
Yes.
Wayne County. All right. Got it. All right. Anything else either of you'd like to say before I do impose sentence?
Just that my client is a very hard worker. He's, you know, on a good track. He did take responsibility and has learned a tremendous amount from this situation. We are asking respectfully that the court follow the recommendation of a 12-month probation.
All right. I do have before I go to sentencing, I do have a community corrections violation. Is that correct?
So it's my understanding there was a violation. However, my client has since obtained a medical marijuana card, which I think perhaps would address the violation.
Okay, this was the one that was sent through. Correct.
Yes.
That's the one. Okay. So he doesn't have the card yet, but the application and acknowledgement of the application and card came through. I think that's what we received.
Okay, I believe is that accurate, Mr. Campbell?
Yes. Yeah.
Okay.
Probably could have done that before. All right. Anything you want to say, sir, before I impose sentence?
No, sir, I apologize. I just want to handle this and get it behind me. That's all.
Sentence of the court, I'm going to place you on 12 months probation. You're to pay $655 fines and costs, $360 probation oversight fees. When can you pay that?
I can start in a couple weeks.
Pardon?
I can start in a couple weeks.
Do you have anything today?
No, sir.
All right. So are you asking for a payment plan?
Please.
All right. I'll do it. A payment plan as arranged by probation. No use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a gun safety class as directed by probation. You're not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. I will order the forfeiture of the weapon, which is the Taurus G2C with the serial number as in the file. I'll order that you maintain employment with verification to probation. I'll order 365 days in jail. Credit to the balance is suspended. All right.
Yes, sir.
Thank you. Thank you,
Thank
Mr.
you,
Cole.
Judge. Have a great day.
You too.
Thank you.
Court calls case People versus Dustin Megason.
Good morning to your honor and to your staff. May it please the court, Joseph Slavin, P number 61705, on behalf of Mr. Megason, who stands to my right. Sir, could you state your name for the record, please?
Dustin Megason.
Your honor, we've had the opportunity to review the pre-sentence investigation report. We find no additions, corrections, or deletions that need to be made there too. Just brief allocution.
Okay. I have a bond violation. Were you aware of that?
I was not, your honor. What's the bond?
That's also set for a hearing today. It appears to me that he operated a vehicle without security.
I was not aware of the, was there no insurance, someone?
Yes, I had been pulled over for. I didn't get no ticket for it. I didn't get no tickets, and I didn't get arrested.
It looks to me, counsel, and I will
I got pulled up.
tell you what I'll do so that you have all of the information. I'll pass the matter and then have my staff give you a copy of this report. So that
That's, I don't have that.
okay, so I'll pass this matter. Go through that with your counsel, your attorney. Sir, go ahead and have a seat. Court does call the case People versus Brenda Miles Roberts. Like,
Yes, good morning, Your Honor. Robin McCoy, P63057, on behalf of Brenda Miles Roberts, who stands to my right.
your name?
Brenda Miles Roberts.
Thank you. Read the pre-sentence report or the alcohol screening and assessment.
You said,
Have you read that?
yes, I did
Okay.
that. And I do have she has letters of support from church, her job, and the doctor that she works for. So, did you want to have a chance to look at that?
Well, that's gonna hold us up because obviously want me to review those.
I do.
I haven't seen them, so
I can email the court if you want to just pass it.
I don't have to.
Brenner, would you like these hard copies?
Yeah, I'm not sure how I'm gonna do this, but that's fine. Yeah, I'll take the hard copy. All right, so I'll pass this, man.
Okay, thank you.
Court does call the case, people versus,
Morning, Paul Spindler, Lawrence County, on behalf of the Steve. Be on Zoom, Your Honor.
yes. Keith,
Hello?
hello?
Yes, I'm here.
Okay, can you turn on your camera, please?
Okay, just one second.
Oh, there she is. Okay. Go ahead, Ms. Barry.
Now, we did review the pre-sentence report. We don't have any material changes, additions, or deletions, and we ask that you adopt probation recommendations.
Ms. Keith, is there anything you want to say before I impose sentence?
No, I don't.
All right. Sentence of the court, $480 fines and costs, 93 days in jail that is suspended. When do you think you can get that paid?
Can I be placed on a payment plan, please?
Do you have anything today?
I will get paid next Friday. I will have something next Friday.
Okay, so what kind of payment plan do you want?
I'm gonna need a couple months.
Okay, so you need.
I can pay 50 next Friday. You said it's $490?
Can you get this all paid off by, say, October 30th?
Yes.
Okay. Then what I'll do is I'll just make it payable by October 30th, but I'd suggest that you make payments in between.
Okay.
All right?
Thank
Okay.
you.
Thank you. Court does call the case, people versus Sean Costello.
This is a public defendant, Nicholas, Mr. Costello. I have been unable to make contact with my client, Deanna, acknowledging his lack of appearance.
Or
She'll cause.
set aside the last bench warrant. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $15,000. I give a 10% privilege. That warrant will issue immediately. Court calls case, people versus Christopher Fair.
Assistant public defendant Nicholas Buckovich on behalf of Mr. Fair.
Christopher Fair. Also show cause.
Yes.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000. 10% privilege. Warrant will issue immediately. Court calls the case of the people versus Jacob Hodge.
Good morning. Joshua Hirsch.
What did I say? I said I have Jacob. I think it's you guys anyway.
Yeah, Jacob Hodge, but it is a me.
I didn't call this one. Assistant public defendant Nicholas Buckovich on behalf of Mr. Hodge.
Not checked. We don't have her. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $7,500. So give a 10% privilege on that. That warrant will issue immediately. Court does call the case, people versus William Kendrick. The keys.
Morning, hearing in the law, Mr. Kendrick. Your name, sir?
William Kendrick.
Thank you, sir.
I spoke with Mr. Kendrick yesterday. He informed me that he was incarcerated in Washington jail for 30 days in May. He lost his job. He is looking for a new job, so I'd ask him for German to give us time to get back up and start making pay.
I'll adjourn the show cause. What's my October date?
October 14th.
October 14th, 2026, 9 a.m. All right. Thank you, Mr. Kendrick.
Thank you. That's my birthday, Your Honor.
Is it?
Yes, sir.
All right. So hopefully people will give you money for your birthday and you can come in and pay us.
Okay, yes, sir.
I know that's bad, isn't it?
All right.
All right, Mr. Kendrick. You take care.
Y'all have a good day.
You do the same. Court calls the case, People versus Evan LeBron.
Good morning, Assistant Public Defender Laura Perry on behalf of Mr. LeBron. I did speak to Mr. LeBron yesterday, more than the Zoom link. I don't have an explanation.
Bench warrant will issue for defendant's failure to appear. Bond will be set at $5,000 to 10%. That warrant will issue immediately. Court calls the case of the People versus Lorianne Pearson.
Good morning, Assistant Public Defender Laura Perry on behalf of Ms. Pearson. According to my report, she paid off the balance.
I have it at 0. I do. All right. She told me she was not paying full. Defendant paid. I was canceled. Court calls case People versus Dallas Williams. So show goes.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Williams.
Dallas Williams. He's not here.
Your Honor, I did speak to Mr. Williams this week about the show cause hearing. I do see that he made a payment on the 11th, which he told me he intended to do. Like, although I cannot explain his lack of appearance here today, I do know we spoke. He did intend to appear, and he did make the payment as he indicated he would. So I would be asking for the consideration of an adjournment.
Well, when did he make a payment?
My court said, give me 1 second. My court said yesterday, 8/11.
How much?
A $50 payment.
Well, the last time we were here, February, he was to begin to pay $100 per month beginning March. And then I said that if he paid the $100 per month, court would consider waiving the $650 bench warrant fees once $1,000 had been paid. And I adjourned it out to May 13th, which I think got pushed to the 27th. I then adjourned out that date to August 12th, today, 9 a.m. And I set that in person, and he's not here, and it's only made a $50 payment.
I understand, yeah, I do remember the last time we were here, he was just returning back to work after a serious injury. So, like I said, I did speak to him. He did make the payment. I cannot explain his lack of appearance here right now. However, I would still be requesting that adjournment.
Bench warrant will issue bond set in the amount of $15,000. They'll give a 10% privilege. That warrant will issue immediately. Court recalls case People versus Justin Megason.
Right.
Your Honor, again, Joseph Slavin, P number 61705 on behalf of Mr. Megason. Your Honor, I did have the opportunity to read through the statement. There was no citation issued. There was a glitch. I did talk to Mr. Megason about what was the deal with the insurance, and he showed me his insurance card, and it is valid insurance now. what it was is he gets paid, he gets direct deposited, but he has his account set up for the automatic payments for the Progressive, and payday and Progressive Day lined up the wrong way on a particular occasion, which means that that payment didn't get processed. And if you're on a payment plan to pay your insurance, they just can you right there. Like, okay, no. So they had basically shut it off. He didn't know. And this actually is what gave him the knowledge to call him Progressive and say, oh, okay. And then he corrected the error, made the payment that was missing. They reinstated his insurance policy.
Just okay.
But other than that, there was no citation issue.
Do we show anything regarding him?
That's what I was curious.
State police.
I don't see anything open for him.
No, I think, and it says in the description that when the trooper, got his license and everything, and that it says that he conducted the stop and realized that he was on bond. So I guess he just thought it would be a idea, because he asked a lot of strange questions to Mr. Maggot. He's like, "You doing any heroin? No, you doing anything? I don't do any of those drugs." I think it might have been just, he says, "Oh, his eyes were bulging out," and it's like, no. And he's done testing here. He's never tested for any substances. So why he took it upon himself to just, I guess, write a letter, making it look like some kind of a report, but it's really a report of nothing. They did impound the vehicle, which they got the vehicle back. The only thing they found
Were put under arrest?
They did put me in the handcuffs, but then I contacted my attorney. I don't know if my attorney got a hold of them. And that's when I got released.
Yeah. Him and his
At the scene?
At the scene. Me and my mother both got released at the scene.
Who?
Me and my mother both. My mom.
They found a circular saw and a couple of bottles of pop in the car, but nothing else.
You're riding around with your mother?
We had just got off work. I was on my way home that night.
The only thing he was given at the scene was the business card for the trooper about where the towing is. And
why am I have a 4-page report about operating without insurance. He put up, he's with his mama, and then there's a line that they request I violate his bond on this case, which has nothing to do with driving.
No. And I think they might have charges.
No.
My guess is that they saw the charges that were pending against him and thought, oh, okay.
I don't know what to guess. Well, that's a good guess. I don't know what.
I think it's you want to mess with the police officer? Maybe the police officer might mess with you back.
He gets put in handcuffs. I get a 4-page report to violate his bond. So I think that's discretionary then on my part.
Very much so.
Right? So I could or I couldn't. I don't understand. He's with his mama. Right? Now, if he had been out running around every place, and I get that. Well, the last line reads, second to last line, I respectfully request the 14th District Court violate Dustin on bond because he was operating a vehicle without security. It's a misdemeanor.
And he should have arrested him for the misdemeanor on this thing.
It's absolutely a misdemeanor.
It is.
One I did, then they issued citation. They didn't issue the citation. So I respectfully decline to violate his bond. I just don't see it. I don't see it either. And
I do think it's a little bit of a waste of resource or tax dollars to send this kind of report in time just to try.
It's just another tree. To me,
My great
I'm not,
won't be able to climb trees like I did when I was a kid or build forts because there won't be any trees to do it with.
maybe not. No,
But-
now you've got a copy of the report, you can save that.
Well, I guess
Right?
some of the, yeah,
All right.
I'm gonna give that to.
All right, with reference to the sentencing.
Sure. Your Honor, before you, Mr. Magnuson, is a hardworking guy. He works 40 hours a week. As a matter of fact, he works with his mom. That's where they were coming from that day. And, yeah, he's a high school graduate, do some ITT tech and still looking to get that job during the schools. But right now he's still, you know what, you do what you got to do in the meantime. And he doesn't have any history. He self-reported. The PSI clearly states that he doesn't have any substance abuse use disorders at all. He maybe drinks twice a year. So does he have a past? Yeah, like from like 7 years ago and a little bit further, some driving on suspended licenses. And that's why he's, having that license was important to him because he finally got that license and everything and got his license all squared away. And he's not that younger guy anymore. He's just asking that, and we're not downplaying the seriousness of the whole incident, but we just ask that we adopt the recommendation.
Anything you want to tell me? No? So he works with mom, drives around with mom, and want me to lock him up. I don't get it. That is
He lives with his brother as well. They have a very close-knit family.
apparently,
Oh, yeah. I know a lot of families who I'm like, they don't talk, and instead, you grow up close. So,
all right.
we just celebrated a 90th family reunion like a couple of weeks ago, and it's really cool. So, for me, I don't know. I grew up from a big family, so
All right, Mr. Mickelson. Sense of the court, I'm going to place you on 12 months probation. You're to pay $555 fines and costs, $360 probation oversight fees. When can you pay that?
Can we put on a payment plan? I could have it paid off within maybe 2 or 3 months.
Can you get it paid by October 30th, you think? Do you have anything today?
I do not.
Why is everybody not showing up with money? You know what? Bet your mom showed up. Mom would have money.
She's actually off of work right now because she just had surgery.
Yeah, okay. Well, wish you the best from us. All right.
thank you, Your Honor.
I'll indicate that it's a payment plan as provided by probation, but he's to have it paid off by October 30th, 2020.
Thank you.
No use of alcohol, recreational marijuana, or any illegal substance will be subject to random testing as requested by probation. You're to complete a substance abuse assessment, follow all treatment recommendations for status reports to probation. You are to complete a behavior modification class. There's to be no assaultive, threatening, or intimidating behavior. You're not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to maintain employment with verification to probation. I will order 365 days in jail. Credit to the balance is suspended. Right.
Thank you, Your Honor. Have a good.
You here.
To read additional person.
Okay, that goes to probation.
I shared
know.
that. I shared that with probation.
Court does recall the case of People versus Brenda Miles Roberts.
Again, good morning, Your Honor. Robin McCoy on behalf of Miss Brenda Miles Roberts.
Is it still morning? No, it's
Nope.
already.
We went over. All right, get it. Good one. This is, I think, plaintiff's emergency motion, correct?
I believe we might have docketed something. It doesn't appear as though the
With final settlement and so I should let you know that I received a email this morning from Miss Lyman. And she's at U of M hospital, not be able to make the court today. And she has her tag on. So that's the first thing. The other issue was, I believe, Miss Anderson had sent to the court based upon, I guess, the or whatever, that what looked like red tags on the door to the premises.
Yeah, my understanding is she's been very prolific in sending proof to the court. And I've cautioned her to have that entered as evidence when it comes to trial. That would be my preference. But as far as the Miss Lyman's non-appearance without formal pleadings being filed or contacting me with news that she's in the hospital, I find that kind of suspect. I would ask that default.
Well, let me just say this. Attached is her admissions tag, but I don't have the date of it. It's around her wrist, but I don't have the date of admission.
Your Honor, my client has heard nothing. I have heard nothing. My client has begged and pleaded for admission to the house so she can assess the damage. She's been refused at every turn. It's high time that we get on with our lives here. I would argue that she hasn't exhibited cause for being absent at today's date with no formal papers filed with court, no contact to plaintiff's counsel or the plaintiff.
It seems to me that I'll give some deference to the fact that she sent the tag in, but the other, I think, problem in this case is that we contacted, based upon the tag command, we contacted Pittsfield. They have indicated that the house is unfit for human occupancy.
If I may interject, that wasn't the problem or the case when Miss Lyman took possession. I've been told that there are holes in the wall, many holes in the wall, more than you can count. Who knows what's going on with the plumbing or the electricity? And both of those are going to cause Pittsfield Township to take notice. I've seen tenants destroy property, and it appears as though this tenant is trying to destroy the property for whatever reason.
Yeah, I'm not prepared necessarily to make that, because there was a list given, but not to us, of from Pittsfield. There is I believe my staff told me, a September 14th check-in to determine what repairs had been done with Pittsfield. And I think they were going to check in with Miss Anderson. That they said September 14th. Again, that may be just for them calendaring thing to try and determine what repairs have been done and do you want another inspection? Which is typically how they would work. So I don't know that the September 14th date means much in any event. So here's what I'm going to do, because we specifically asked, because it was red tagged, whether it was condemned. It was we were informed that they don't use that terminology. So I don't know. I'm not sure what to make of what they're saying.
So whatever the verbiage is, maybe it's not condemned, maybe it means the same thing.
Well, right. I kind of thought, sometimes in this world we want to say something, but everybody thinks that that's a bad word, so we make up a new phrase for whatever. And I get that. So what I think I'm going to do is this. I'm going to kind of split the baby here, where I won't. I'm not going to give a judgment or do anything today because she's not here. I think at least has sent the thing in saying she can't be here.
Oh, Your Honor, excuse me again.
Go ahead.
I was told that she hasn't paid escrow for August, and we're into August now.
Right. She has not. But the only thing that would entitle you to is an immediate trial for possession. I think it's going to be, I think it's going to be the long and short of it happening in different ways. What time is the miscellaneous block on Friday? 3.
Yes.
All right. So I'm going to adjourn these out to this Friday at 3.
Very good.
Person. And at that point, be prepared to do something. I should have, if she can't be here or whatever, I'm just going to make my ruling on what's there.
Very good.
Okay.
Thank you very much, Your Honor.
Thank you.
Thank you.
Just give me searching. Oh. Like the problem. What? Like, you're like a Jordan.
This month. 6 check.
Chicago Paul. I didn't know you were. I hate you. All right.
Wow.
What business? All right, stay tuned. Go ahead, Ken.
Your Honor, Ashley Dolinsky on behalf of petitioner Ruth Fisher.
Your name?
Ruth Fisher.
All right, this is your petition, so go ahead, Counsel.
Would you like me to start by voir direing her? Would you like me to speak on her behalf? What would you prefer?
You could speak on her behalf.
Okay. Okay, Your Honor, this is Ms. Ruth Fisher. Ms. Fisher is asking you today to please set aside 4 misdemeanor convictions: retail fraud in the 3rd degree, purchase of alcohol by a minor, operating while impaired, and operating while license was suspended. Ms. Fisher accepts full responsibility for the mistakes that brought her before the court. Does not minimize or excuse her past. Looking back, she recognizes that alcohol had a much greater hold on her life than she understood at the time. Several years after the conviction before the court, she reached a turning point after serving jail time while pregnant on a later alcohol-related offense. She realized that she was on a path that would cost her everything that mattered, and she made a decision to change her life. She followed through on that commitment. She participated in outpatient treatment services through Home of New Vision. She separated herself from the people that fueled her addiction, and she remained continuously sober since May 2017. She's also fully complying with every requirement of Michigan driver's license restoration process, including the use of an ignition interlock device. Today, Ms. Fisher has been steadily employed by Trinity Health for the past 3 years as a medical assistant in workplace health. She and her fiance have been together for 13 years and are raising 2 children, ages 7 and 8, who attend STEAM school in Ann Arbor. They've built a stable home, strong family relationships, a supportive community in the Arrowwood neighborhood. Despite those accomplishments, this conviction continues to hold her back. She cannot attend nursing school and continue advancing her career in healthcare, and she cannot volunteer at her children's school. She's not asking the court to erase her past, but she's asking for the opportunity to have her record reflect the person that she spent the last 9 years becoming. So the purpose of expungement statute is to recognize rehabilitation when it has truly occurred. Ms. Fisher's actions demonstrate that rehabilitation. She's maintained nearly a decade of sobriety, stable employment, a loving family, and a commitment to living responsibly. For those reasons, we respectfully ask the court to grant her application today.
What do you have to say for yourself? Did I send you to jail?
Yes.
Yeah, I did. I know.
Yes.
And what did that mean to you? Why do you think I sent you to jail?
Because of what I did.
Did you think you deserved it?
At the time, I probably did. Yeah.
Yeah.
Mm-hmm.
Not a good experience, right?
No, not at all.
All right. So what else are you doing with yourself?
Just busy being a mother, working.
Just being a mother. Okay. For all moms out there,
That's a lot.
okay. And you want to go to nursing school?
Yes.
Where?
I think Washington.
Over at the community college?
Mm-hmm.
Tell you a little secret about that program.
Mm-hmm.
My dad was a counselor at Washington.
Okay.
Way back a long time ago. And when the nursing program first started there, he was a counselor assigned to the nursing program. So I have a great attachment because I also teach over there.
Oh, nice.
And my mom was over there. And I have a great attachment for the nurses that go through that program because it's a good program.
Mm-hmm.
So this holds you back. You also can't volunteer at your kid's school.
Mm-hmm.
That's gonna hurt.
Yeah.
Yeah. All right. Anything else you?
Sorry, I don't know.
You're nervous right now, right?
Yes, I am.
Every time before you
done this
run
in a while.
some of it didn't go real well.
No, I didn't.
But anything else you want to tell me? No.
I've learned a lot from my mistakes, and I will not do this again.
You think about it though, isn't that what life's really about?
It is. Yes.
Mistakes.
Mm-hmm.
The important thing is not to repeat them.
Correct. Yeah.
Right. And you're a different person now.
Oh yeah. What's different? Yeah.
Court having read the petition and having heard the allocution of counsel, as well as the defendant, the court, and an opportunity for the attorney general and the prosecuting attorney to contest this application, there being no contesting of this application. Court does believe, based upon the allocution, that the circumstances, behavior of the applicant from the date of the conviction cases to the application do warrant setting aside the convictions and is consistent with justice and the public welfare. Therefore, the petition to set aside the convictions is granted in all of the cases.
Thank you.
You're welcome. Good luck to you.
Thank you.
Thank you, Your Honor.
Thank you. Oh, so good to you. Court does call the case of the people versus Shirozi Martin.
Good afternoon, Your Honor. Hassan Zaror, P83043, standing in on behalf of Attorney of Record for Ms. Martin, who appears via Zoom. Ms. Martin, can you please unmute your device and state your name for the record?
Hello, I'm Sherazad Martin.
Thank you.
Counsel, your petition, you go ahead.
Your Honor, thank you very much for the opportunity. This is a motion to set aside a conviction for operating while visibly impaired. Your Honor, we have received indication from the Attorney General that Ms. Simpson is eligible to have this conviction set aside should her post-conviction circumstances and behavior warrant setting it aside, and should it be in the interest of the public welfare. We also have her Michigan State Police report, which shows that this 2013 conviction is the only conviction that she ever got on her record. Your Honor, it was some 13 years ago. She is fully statutorily eligible. She is not the same person that she was some 13 years ago, and this has impacted her ability to move on. And whenever she applies for jobs or housing or anything else, it does come up, and it is a stain on her record that she is deeply remorseful for. And Ms. Martin is here to tell us a bit about what she's been up to since, how this conviction has impacted her, and how setting it aside will be in the interest of the public welfare.
All right. Ms. Martin, what do you want to tell?
Yeah, I mean, I definitely made a big mistake. 13, it's very serious, and I take responsibility for my actions. Alcohol definitely is something that was affecting my life in a very negative way. Since then, I have not gotten in trouble at all. I've turned my life around. I actually work in helping working folks get connected to media resources. And yeah, I just I would like the ability to be able to apply for jobs. I want to go back to school to be a dental hygienist, and I would like the ability to apply for jobs and for travel, to travel with my family, with my mother and my sister, without, and my husband, without this coming up, you know. So I would really appreciate and you considering expunging this off of my record.
Okay. Couple of things there. It was really funny. You want to travel. You first of all mentioned mom and sister, and then, oh yeah, and with the husband too. So I picked that up. All right. You said you young adults connection with media. What was that you said you did? You're muted.
I connect working people with media resources. So if they want to do an op-ed or an LTE, I help prep them for that. I find them we work with a communications firm that helps them with that, as well as, yeah, so all kinds of things.
Interesting. I didn't realize there were people out there that did that. You live in Detroit?
Yes, sir. With my husband. Okay. And I would like to say,
no, you can't make up for it. With my husband, I don't want to travel with him, but
no. I just would like to travel with my mom and give her experiences. I mean, she supported me for so long, you know. And I would like to travel with him too, but that's why I said her first.
Well, no, you don't understand. Since you brought it up again, mom, I get all of that about traveling with mom and wanting to. I get that one, but before husband, you threw sister in there.
I can't travel without my mom, without my sister. She would be upset. So
okay, so they were like a pair that come together, and then the husband. I hope he's watching. I just because you're gonna have some explaining to do. Because oh, great. And you said you wanted to go back to school. What do you want to do? You want to become a dental hygienist?
Yes, sir.
Why that?
Right now, my work is a little bit intense, and I would enjoy just having a skill that I could do that's more coming to work, focusing, doing stuff, and then leaving it at work, you know?
Oh,
So
okay. I see. You don't want that round the clock thing. I get it. All right. Well, probably should call her husband, see if he wants this granted, but I'm not going to do that. Court, having heard the petition and the allocution of counsel and an opportunity having been given for the Attorney General and the prosecuting attorney to contest this application, and there having been none. The court does believe that the circumstances of behavior of the applicant from the date of the applicant's convictions to the filing of the application do warrant setting aside the convictions and is consistent with justice and public welfare. Therefore, young lady, your petition is granted. All right. Thank you, folks. I've signed the order.
Thank you.
You're
Thank
welcome,
you.
sir. All right, and good luck to you and best in the future. All right. Take care.
Have a blessed day. Take care.
You do the same. 14A stands in recess.
All rise. 14A District Court for County of Washington, State of Michigan. I'll have the second, the Honorable Judge JudgeSimpson preside.
You may be seated. Have Gilmer. It's over here back there. Court does call the case of the People versus Christopher Gilmer.
You have the table, Your Honor.
Good afternoon, Your Honor. Adam Dreher with and on behalf of Mr. Seated to my right. Good afternoon, Your Honor.
Good afternoon, Mr. Gilmer. Can you just state your name? Thank you. You know how. I'm dismissed. All right, what are we doing?
This time, people will be unable to proceed as to count one would ask for to be on count two industry.
You're moving. Go ahead.
Certainly, Your Honor. I mean, at this stage, I don't believe we can object to the misdemeanor moving forward. I do understand and have counseled my client in terms of what a dismissal without prejudice would mean as it relates to count one. Certainly, we would support the dismissal of that count.
You're moving to dismiss count one.
I believe that's what the prosecutor moved for.
No. Prosecutor indicated they're unable to proceed as to count one. You would have to make a motion to dismiss count one.
We move to dismiss count one here.
All right. I'll grant that motion to dismiss count one. I'll continue the defendant's not guilty plea as to count two. I'll set pretrial.
August 13th at 9 a.m.
August 13th, 2026, 9 a.m. before Judge Barr. Is that who you have? Yes, Judge Barr.
If I may address bond, Your Honor.
Yes, you may.
All right. I believe the magistrate set a bond in accordance with the severity of the felony offense. Certainly, my client has already had another misdemeanor case. I would ask that the court impose a bond in this case along with fines.
Well, I don't know what that is. You said he's got another bond in a misdemeanor?
That's correct.
So what is that?
$100 bond, Your Honor. It was going to start.
Where's that one at?
14A2 also.
At 2? Got it. Okay. So that was set so he get credit while he's on this one. Okay. Response?
Yes. Mr. Gilmore has a very extensive, including multiple RNOs along with 2 previous dismissed home invasion first in 80 seconds from last year with the same victim. So I do have mercy to give this history and pattern of home invasions and DVs with this statement. I'll be asking that bond continue in this case.
Obviously, there's a prior conviction for domestic.
In December of last year, involving 2 separate home invasion first DV second cases with the same victims that made it up to the court before Judge Collins, where they were ultimately dismissed by the people.
In response, I've just outlined this incident is not those. During this incident, my client did in fact call 911 himself. He understands that the relationship that he had not healthy and would not oppose any sort of no contact or even just be opposed to ensure that that no contact then is enforced. It's my understanding my client doesn't want anything to do with this individual anymore. As the prosecutor mentioned, he spent nearly 6 months in jail last year awaiting trial on that case that did not move forward. For that reason, I don't believe he should be continued to be held. Another case which likely to have the same outcome. So we would ask for the bond to be reduced in line with the retail fraud case, Your Honor.
And Your Honor, I may note for the record, in that case last year, there were multiple things, not on the people's behalf, but on a previous attorney's behalf, that kept Mr. Gilmore in jail. People at that last case were willing to stipulate to him being released prior to that dismissal due to the concerns of people that was not going to receive, or that stip was not promptly, or a plan also was not given to the people. And that is what caused Mr. Gilmore to be held longer than anticipated in that case. I just wanted to put that on the record.
All right. I'll modify the defendant's bond not to the extent that the defendant wishes, but he's set right now with a $25,000 cash surety. I'll lower that to a $10,000 cash surety bond. All right. All conditions remain in effect. All right. Thank you. Good luck, Mr. Gilmore. Well, Judge Barr can take a look at it once it gets over there because he's got your other case. So he may do something else once it gets there.
Thank you.
All right. You're all set.
Thank you, Your Honor.
Thank you.
Today's courtroom session brought a mix of sentencing decisions, probation violations, missed appearances, and second chances. One of the major moments involved a defendant who came before the judge for sentencing. His attorney described him as a hard worker who had taken responsibility and was trying to get his life back on track. The judge ultimately sentenced him to 12 months of probation, with fines, probation fees, random testing, employment requirements, and strict restrictions on weapons and substances. The courtroom then became much stricter when several defendants failed to appear. In multiple cases, the judge immediately ordered bench warrants and set bonds ranging from $7,500 to $75,000. But not every defendant received harsh treatment. One defendant explained that he had lost his job after spending time in jail. The judge chose to adjourn his show cause hearing and gave him another date to return to court. Another important case involved a defendant accused of driving without insurance. His attorney explained that his insurance had actually been valid, but an automatic payment problem caused the policy to temporarily lapse. After reviewing the circumstances, the judge declined to violate his bond, saying the situation did not justify taking that step. The hearing also included a DUI-related sentencing, where the defendant was placed on 12 months of probation and ordered to complete alcohol education, attend AA meetings, submit to random testing, and follow other rehabilitation requirements. The judge eventually discontinued the SoberLink requirement after determining she had already complied for an extended period. Later, another defendant received 24 months of probation, substance abuse treatment, weekly testing,